Good afternoon. Good evening if you are in Europe. I'm Ludivine Worksik, the Executive Director of the French-American Chamber of Commerce based in Boston. It's my pleasure today, in partnership with the British American Business Council of New England, to welcome you to this webinar. Today, we are thrilled to welcome three experts from Fragomen and Clark Law to give us an update about the immigration under the Biden administration. Thank you very much for your participation. You have the possibility to use the chat to ask your questions. And now the floor is yours, Scott.
Thank you, Ludivine, and thanks so much to you and your colleagues from the French-American Chamber New England for helping set this thing up. I'd also like to thank my colleagues from the British American Business Council of New England. Our firm has been a long-standing member of the French-American Chamber and the British American Chamber. I actually serve on Babsny's board and one of the members of its executive committee. Clark Law has also been a long-standing member of the British American Business Council of New England, and I think this is the second time that Vince and I have put on a program like this, and we were delighted that his partner Magaly kindly agreed to join us today. So what we're going to do is run you through what's going on with the Biden administration, what we perceive in terms of U.S. immigration progress. I think, we're making progress. We're definitely in a different environment, regardless of your politics. There's no question that the Trump administration had us in its crosshairs. And so, anything is an improvement in terms of the attitude of this administration towards business immigration. So we're delighted that we're in a different environment. To that end, we're going to cover the latest on the COVID travel restrictions and national interest exceptions that you can apply for to get around some of that. We're going to probably give you some not great news about what's going on at the U.S. embassies and consulates around the world. We're going to talk about the Biden administration's priorities and legislative initiatives. And then for our expats, there's lots of expats on the call. We're going to talk about some good updates regarding naturalization process and eligibility. We're also going to talk about ESTA requirements, how you can travel into the United States, what you need to do as a visitor. And then we'll give an update on this most recent H-1B cap filing season and what we see coming down the pike. So that is an overview. We had a huge demand for this webinar, and so we're going to take questions at the end. But please do feed them into the chat. And I'd like to thank my associate, Mike Moore, who's in the background. He's advancing the slides and monitoring the chat room. So we should be able to field questions at the end. With that, Vince, I'm turning it over to you.
Great, Scott. Thank you very much. So the first topic that we want to cover is the current travel concerns and restrictions during COVID-19 and during in the context of some of the presidential proclamations. Probably not a surprise to everyone around the world. COVID-19 is a real issue, and unfortunately, it doesn't look like it's getting any better while we have hope. Right. So I do like to think when we think about international travel into the United States, at least, I usually like to think about it in terms of the different bans out there. There have been presidential proclamations issued by the Trump administration and most recently sort of revised or lapsed in the Biden administration. So we want to talk about that a little bit. But as far as the bans are concerned, I think oftentimes a very practical question is, can I travel into the United States? So the first thing on a general level is that from an immigration standpoint, individuals other than Canadians will need a visa, which is a stamp in their passport. And then the question is, how do you get a visa? And most visas are actually obtained from the US consulate. And Scott will talk a little bit about the latest in terms of consulate operations. But there was a visa issuance ban. So the initial question I often ask people is, do you have the proper visa? Do you have the proper documentation? So the visa issuance ban prevented people from getting new H-1B visas and L visas, H-2 visas and J visas. The good news for that is that lapsed, that issuance ban lapsed in March 31st, actually just a few days ago. But there are practical practical implications of that as far as getting an appointment with a consulate. And Scott will talk about that a little bit later. But the other very relevant ban that still exists is the travel ban. And the idea behind this is that individuals who have been in any of the restricted countries within the last 14 days are not able to travel directly into the United States. And so the regional travel ban consists of China, Iran, the European Schengen countries, the UK, Ireland, Brazil, and most recently South Africa has been added. One thing I will say from a very practical perspective is that if individuals have all the proper documentation and go somewhere else, not one of the listed countries, for at least 14 days, then they're able to sort of avoid this regional travel ban. The other thing very practically is that if there is a layover, so if you're not coming from one of these countries, but your flight happens to end up in one of these countries, even for a short layover, sometimes that's a problem. And we've seen that with a lot of our clients. Now, if you are subject to this, I know we have a lot of people here connected to the UK and connected to France. How do you get around that? So we can talk about the national interest exceptions, and that's sort of the next slide. There are national interest exceptions to the presidential proclamation. Ideally, you have to put forth a really good argument that you should be allowed to come into the United States, because the regional bans really have to do with sort of protecting people here in the US from COVID-19. And most recently in March, the State Department actually revised some of its requirements, making it a little bit more narrow when it comes to executives and travelers for business reasons. Some of the other exceptions still exist. And I think the important thing is to think this: when an individual is hoping to get an exception to the bans, you want to think about, are there any arguments to show that they are going to be providing what is called vital support for critical infrastructure? And we have listed here on the slide some of the critical infrastructure industries that the government will look at. From a very practical perspective, I would say make sure you always check the website for the State Department and also for the particular consulate, because each one will have their own requirements and what needs to be done. But most national interest exceptions will require the individual to be outside of the country. So I'm sure Scott and Magaly and I represent a lot of executives who are here in the United States who want to travel abroad. And obviously it's very risky because all these national interest exceptions are discretionary. There's no guarantee, but we can't apply for these until the individual is outside of the country. So I would say practically make sure you have some time and have some flexibility in terms of your planning. There are still some exceptions. If you have any US citizens who are immediate family members, there may be an exception to this as well. Again, I think look at the slide, but also look at the website for the particular consulate for the very specific instructions on how to apply for it. The other travel restrictions to think about are the fact that the US Canadian and US Mexican borders are in theory closed. So the land borders are closed, and that is anyone traveling into the United States through the land will have to demonstrate that they're actually participating in essential travel. All right, so vacation, leisure, half my family's Canadian, by the way, right? So we couldn't go to family weddings over the fall because this was closed. The land borders were closed. Now, air travel is a little different. And obviously, if you're coming into the United States because of visa reasons, you should also talk to Immigration Counsel to see if you fit into one of the essential travel options as well. So we're just going to move along a little bit, and I know I reference the consulates a lot, so I'm going to kick it over to Scott and let you share some of the not so great news, Scott.
Yeah. So thank you, Vince. So essentially, as everybody knows, right, the world's been shut down for over a year, and so that means that people haven't been coming in, and people haven't been applying for visas, and in addition to that, people haven't been applying for family-based green cards from abroad. So for folks on the line who are in the immigration space, you will recall in the fourth quarter of last year, we all had a scramble to file, literally thousands of adjustment of status applications for folks who are here in the United States to apply for their green cards through employment. And that was an anomaly. That type of a spike had not happened, I think, in about 13 years. Why did it happen? Well, in part, it was because there wasn't anybody coming in from abroad. So a lot of these family-based green card applications had been sitting, and it freed up a bunch of numbers for people who were already here to file for adjustment. And so that caused a huge spike in work. And we, scrambled around and filed all these cases, but those family-based green card petitions are still pending. And so if you look at the second part of this slide here, in January 2020, there were 75,000 immigrant visa cases pending with the National Visa Center. That's part of the process. After they get processed there, an appointment gets scheduled at a consulate abroad. Well, there weren't any consular appointments available. Now in February 2021, there's 473,000 immigrant visa cases pending abroad. That's just staggering. And as you look above, only 43 of the 233 posts around the world, those are consular posts that process routine non-immigrant visa applications like H's or L's, are doing so right now. So big problem coming, right? So here's what's going to happen. People are going to get vaccinated and they're going to say, okay, I've been sitting outside the US for over a year. I'm ready. Get me my visa appointment. I'm coming in. And all of a sudden you're going to go online and you're going to say, I want to apply for my visa in Chennai, and the appointments aren't available until January of 2022, something like that. That's the scenario. So what do? Well, we're going to push the State Department. We're going to push the administration, and even consult with Congress to try to address this. The other problem, and it's listed here, is that we were in a tough business for 4 years, so there weren't a lot of people applying to join the Foreign Service to become consular officers, and a lot of people left. So in addition to the 500 openings for the folks that process these visa applications, the number of applicants to join the Foreign Service has been way down. So we got a little bit of a perfect storm coming in terms of staffing at the consulates abroad. And we just want to alert people to this fact, because it's not enough to say, I've been vaccinated or my country is opening up. It's more than that. There's a logistical step that we're concerned about. And we are raising this to the State Department, and also suggesting mechanisms by which they can move work around to non-Foreign Service officer staff, so to free those folks up to sit in the window and process these applications. So that's one heads up. The other piece of this is that the ban, this big ban that Vince mentioned, and that the U.S. Chamber of Commerce and the National Association of Manufacturers filed a lawsuit, and big fight over this ban on H's and L's and J1 visa holders coming in. It expired on March 31st. So last week it went away. So you'd think, okay, great, same thing, like the floodgates open, here we come. And the answer is no, because of COVID, right? Right now it's because of COVID. Even in India, I just read this morning that one of the provinces is locking itself down from, I think it's 5 o'clock Friday afternoon until 8 a.m. Monday morning. I mean, the infection rates are spiking. So that's a piece of it. And then the staffing problem is another piece of it. One piece of good news is this non-immigrant interview waiver extension. So that means that instead of only people who have been issued a visa in the last 12 months being eligible to get a new one without an interview, now it's 48 months. So that could be helpful, except most of those people are already here. You're either here or you're there, right? So a lot of the folks who may qualify for this exemption are already here, and the other people would be trying to find their way in based on these COVID restrictions. But it is a sliver of good news on the consular front. Okay. I'm going to shift gears real quick. I'm just going to introduce this concept, and then I'm going to turn it back over to Vince. As I mentioned, we're in a much better place, right? There's no question that we've gone from an administration that really wanted to close our borders to one that's much more interested in supporting what we do. So there is a plan, and there's an immigration piece of legislation which we'll talk about. But the big picture is that the Biden administration is much more in favor of immigration, but it's not really so much about business immigration. It's about DACA. It's about refugees. It's about asylees. It's about making sure that kids aren't separated from their families at the border. And it's about family immigration. And if you looked at President Biden's, then candidate Biden's immigration platform in the election, page 20 was the first place where they actually, or item number 20, where they actually made any reference to business immigration, and it was talking about raising wages for foreign workers. So it's going to be a tricky little dance here. So that first issue, wage-based allocation process for H-1Bs. This is scary stuff for a lot of our clients, especially the universities. If you can't get an H when you graduate from a U.S. university where you paid full freight and you got to go home, why are you coming here? So we think that the universities are going to push back hard on this, as are startups, as are the consulting firms. So there are a lot of companies that utilize recent college grads, and if there's no mechanism for them to stay here, then there's going to be an issue. The plan to eliminate some of these employment-based immigrant visa quotas, I made mention of the fact that we were able to file a bunch of adjustments. I mean, we're the only country in the world where you got to wait 10, 15, even 20 years to get permanent residence because of our antiquated allocation system. So that would be great. And that seems to be something that could happen in the next 2 to 4 years. The legislation includes reducing numbers when there's high unemployment. Interesting, it doesn't increase numbers when there's low unemployment, but it is what it is. So that's a part of this proposal that Vincent and Magaly will get into. And then a quota on U.S. STEM PhD grads. We think that's great. If somebody graduates with a PhD in a STEM field, they get a green card. They say green card stapled to their diploma. Okay, we'd actually like to see something along those lines for master's graduates in STEM, but that's probably not going to happen. There is an initiative to allow cities, and it should say counties, not countries, to petition for immigrants on their own, right? So as the city of Boston could say, okay, we've got an allocation of 50 green card cases, and we're going to sponsor these people to do work for us. And then there's a huge problem coming. Just an article yesterday, I think, in the Boston Globe about what are these restaurants going to do out in the Cape when everybody's free to come and eat out and they don't have any workers. And so they are very dependent upon the H-2B seasonal visa program, and the consulates are closed. And so there's a big mess coming. And there's also an argument with the stimulus, right? The stimulus that just went out, some of these folks are like, I'm going to wait. I'm not going to come back to work yet. So there's a huge shortage of folks. And I think there's going to be a lot of pressure to try to bring in people from abroad to fill these jobs. The Democrats always have been champions of enforcement. Enforcement's a fascinating thing. 75% of agricultural workers in the United States are undocumented. Think about that for a second. 75% of agricultural workers in the United States are here without legal status. And why are we not running out and rounding up all these people? Because we need them. We need them. So it's just an interesting thing. So it'll be that's a really tough dance that they're going to have to address, and we'll see how they're going to do it. Mike, next one. Thank you. Okay, so just again, big picture. There was a bill that was introduced on February 18th. And as everybody knows, there's a majority in the House and a very, very, very slim majority in the Senate. So very, very tough to get anything through. There's this concept called reconciliation, where basically the Democrats have two bites at the apple. They used one for the COVID stimulus package. They're probably going to use the other one for a infrastructure bill. And then there's some theories out there that it may have three bites at reconciliation. Who knows? And whether immigration is the third most important initiative, I don't think so. So the chances of this legislation certainly getting passed in its current state are slim. But what's in there? Permanent residence for folks who have DACA, TPS, and agricultural workers. So that's a big deal. So what do? You go out and you say, if you can prove certain things, those 75% of that workforce, we're going to legalize them. And it's a huge deal, right? And it's also politically difficult and challenging, but that's part of this. These extensive green card backlogs, these folks from India and China waiting 10 to 15 years, or from Mexico and the Philippines, if they're family members, waiting 20 years. to get in. They're going to try to clear some of this stuff. We talked about STEM PhD grads, distribution of H-1B based on wages. That's tricky stuff. And so that's a place where I think organizations like the U.S. Chamber of Commerce are going to say time out, or the National Association of Universities and Colleges, like they're going to lose it. So there's a big fight right there, and that's just one issue. And then, good news for our H-4 spouses and children of H-1B workers to get work authorization. There's also a push to try to get similar work authorization for, O1 spouses, that kind of thing, to widen that out to more people. Final point, it's going to be a lot of debate, a lot of amendments, and that's just assuming they even get it to the place where they're debating, and that it's not on the horizon right now. So the prospects of this coming into to being are unclear at this point. Vince, I turn it over to you.
Great, thanks, Scott. And I just wanted to comment on a point that Scott was referencing in terms of wages. I was on a call with the, at that point, President-elect Biden's administration. They had an immigration transition team. And I was in on a call, and we had actually raised the question in terms of employment-based immigration. And one of their biggest concerns is they want to make sure that the worker is protected. And I do think that that's where the higher wage concern comes in. And I think it comes in from a different perspective. I know that with the Trump administration, it was just looking at sort of protecting the US market versus the individual. What I do want to raise, and I think Scott will agree with this, is that employers who are employing the H-1B or any foreign worker is not paying them cheap wages. It's just that the wage requirements are not meeting the current definition of some of these wages. For instance, the Department of Labor will actually require you to look at the base wage. Startups, we know that a lot of them will have bonuses, or they'll have other types of compensation that will make the final package actually a lot higher. And so the good thing about the current administration is that they're open to hearing. Right now, there is a rule out there inviting businesses, employers, and chambers of commerce to sort of weigh in, to sort of provide insight as to what do you think is a fair way to determine what's the right wage for these individuals. Obviously,
just to chime in on that, I would go so far as to say that the way that the original proposal was put out by the Trump administration just presupposes that I don't know, Apple and Facebook and Google and Amazon are all underpaying everybody, which is ridiculous, right? If you have a master's degree in a STEM field, you should be able to be paid a very good wage. And for us to presuppose that somehow you're being underpaid is I think a little bit silly.
Yeah, no, and you're right. So I think while on the surface, the Trump and the Biden administration proposal may not look that different, it is where they're coming from, the source or their perspective that's a little different. And hopefully with a different perspective, the Biden administration is open to more discussion. And I do think that, as a democracy, that allows more businesses, more employers to get involved and put their insight. So anyway, so that's just something to think about, right? So I think one of my goals in life is to debunk the mission that foreign workers are cheap. They're not. In fact, you'd have to hire Scott or Magaly or myself, and who wants to deal with the lawyers, right? So anyway, that said, let's move to the Biden bill, right? What the Biden administration has proposed, and Scott's highlighted this a little bit. Some of the issues with the current system is that as an employer, regardless of your size, right? When you're trying to retain talent here in America, beyond just some of these short working visas, they want to get them a green card. And it seems crazy to the rest of the world, and Scott is engaged in conversations with employers, just as Magaly and I have, is that, oh, by the way, because they're from India or from China, it's going to take over 10 years to get them. I mean, China a little faster, but still, we're talking about years. And because it's employer specific, it's also job specific. I mean, who stays in their same job for 12 years? So one of the push...
Me and you.
I'd like to think my job's changed a little bit.
That's true. Mine too. Anyway, sorry.
Zooming as a new job duty. But anyway, but I think long and short of it, the idea is that the reform is to find ways to make the time shorter. And so, one way is to change the way immigrant visa numbers are counted, whether it's to exempt, as Scott had alluded to, people with PhDs from the US who've really studied, we've trained them here in the United States. Why are we sending them away? Let's keep the talent here. And also, of course, increasing some of the numbers and maybe counting or not counting, the dependents as well. So there's different proposals as to how to count. There's also obviously sort of as a compromise, there's this downward adjustment of numbers if the economy's back, right? Like if there's a lot of unemployment, then do we really want to have the optics, right? Because politics and immigration are optics in many ways. Is do we want to have the optics of allowing all these foreign workers to get green cards and stay? We want to make sure that the U.S. labor market is protected. And ironically, as Scott has pointed out, there's no way to up the numbers, when we really do need it. But we don't know. There is, the next point is an economic stimulus pilot, which will allow, certain areas to sort of have more numbers if the need be. In the past, I've been practicing for over 20 years, and in the past, when we talk about H-1B numbers a little bit later, we know that there's a cap, but in the past, when there was a tech boom, the number went from 65,000 to 195,000 for a very short period of time to allow for that need. That number has come back down to 85 now and has stayed at 85,000. But it's not out of reason or out of our norm to see an upward number as well. So as we move on to the next slide, I'm going to pass the torch over to Magaly as she talks about some of the non-immigrant, so short-term work visas and what's proposed there.
Thanks, Vince. So as Scott has alluded, there's definitely some proposals to reform some of the more popular work visas, short-term work visas like the H-1B. Certainly this new proposal to change in how the H-1B lottery program is conducted by replacing it with wage-based considerations may benefit some employers, some larger employers perhaps, but it will certainly be a detriment to some other ones like nonprofit organizations, startups, even hospitals that are in rural areas. So we are wondering how this is actually going to play out indeed. Likewise, the fact that now H4 spouses and the children of H-1B workers would be able to get work authorization without the need for an approved I-140 would be excellent. There's many people here that are on dependent visas that are unable to work, and this would definitely be a great benefit for these individuals. The other point here that I would like to highlight is certainly how this bill would offer the opportunity to protect the children of individuals who face long waits to be eligible for green cards. Currently, certain individuals, if the child reaches a certain age, and they might not be able to get a green card anymore under dad's father or mother's green card process. And even though there is a law, the Child Status Protection Act, that may protect certain individuals, not many of them would be protected. So this particular proposal would really allow for these children to be able to extend their status and be able to continue to maintain their own lawful status as well as a parent. So this would be great if it does pass. Likewise, there is a proposal to extend a person's stay past their normal limit. So if you're here on an L1, for example, usually you can only stay here for 5 or 7 years, depending on the visa category that is used. And at this point, if this bill was to actually pass, it would be possible for the individual to continue to extend their visa status for another 1 year increment up until they get their green card. Right now, that's only available for people who are on H-1B visa. So this is actually excellent proposal if it does pass. The bill also contains a provision under which the government can impose a fine of up to $5,000 per violation where there's any federal, state, or local government agency finds that an employer violated any laws concerning the wages, labor relations, family medical leave, occupational health and safety, civil rights, or non-discrimination laws. So this certainly goes back to what Scott is saying, that there is a push for adding more enforcement to these visa programs. There's also a proposal here for DHS and DOL to make recommendations to improve certain employment eligibility verification systems like I-9 systems or E-Verify. And again, we'll see how this plays out, because I think at the end of the day, it's also a budgetary concern that they will have to, whether or not they'll be able to implement any of these recommendations. And with that, I'll pass it off to Vince to speak about the family-based reforms.
Yeah, thanks, Magaly. And as far as the family-based reforms, I think it's very similar to the employment side in the sense that the end goal is to re-examine the immigrant visa numbers and how long it's going to take. So, you know, as you can see from the slide, there are a few points here. You know, how to reuse or recapture some of the immigrant visa numbers that actually aren't being used in some of the other categories, and also exempting spouses and children of green card holders. Currently, if you are married or if you're a child of a US citizen, you're actually not counted. There's no need for you to wait for an immigrant visa number. We call them immediate relatives, and there's a proposal to count from a green card perspective to look at that as well. And then there's also the idea that if it's really taking the government that long, more than 10 years, then maybe you shouldn't be penalized for that, and they want to be able to grant you that. We're going to move this along a little quickly because I know we're seeing a lot of great questions. So I'm going to have Magaly just touch upon the updates on naturalization, which is the citizenship piece, a little bit as we move forward with some of the other topics. Magaly?
Thank you, Vince. As Scott alluded, there's many people here perhaps are interested in citizenship or naturalization. So some key things to note is, in general, people can, if you are here for legal permanent residence for 5 or 3 years, if you meet certain requirements, you can apply for naturalization. And I think the biggest thing here that happened last year was that since 2008, there was a civics test that was being used to really test the knowledge of the applicant on US history and government. And the civic test used to be only 100 questions that were already pre-written, and so you would memorize it, you would study it, you would make sure you could answer 10. The officer would ask about 10 questions, actually exactly 10 questions, and you would need to answer 6 out of the 10 correct in order to pass the civics portion of the exam or the interview. What ended up happening was that in December 1st, 2020, USCIS implemented a revised version of the civic test in which it added 28 more questions to the 100 questions that were already required in the 2008 civics test. And now, or at that point, you had to answer 12 out of 20 correct. Currently, though, thankfully, naturalization, as beginning April 19, 2021, USCIS will offer only the 2008 civics test for the interview. And so some people that may have applied at a certain time or they have their interview before April 19, 2021, they'll have the option of either taking the 2008 civics test or the 2020 civics test. And with that, Vince, you want to cover on ESTA?
Yeah, so we'll definitely talk about ESTA, and many of you who are from the UK or from France will know that there's the possibility for you to come to the United States for up to 90 days without having to go to the US consulates to get a visa. Scott's already mentioned how difficult it is for individuals to schedule appointments because of the lower staffing due to COVID or due to openings there. And so as far as ESTA is concerned, it's very easy. You go online and you just register. I think there's some takeaways from that is, number one, ESTA will allow you to come to the United States for business or for pleasure for up to 90 days. And a question I often get from people is whether or not it is a cumulative 90 days, in the sense that, you know, if I came 30 days already, am I then limited on my next trip to no more than 60? And the answer is no. It is up to 90 for every trip. That said, I also have the flip side is that people think that they can work in the United States up to 85 days and then go home and then come back. And that's not the answer, right? ESTA does not allow you to work in the United States. And working in the United States has nothing to do with where your payroll is, right? So if you're here in the United States and you open your laptop and you're doing a work product, regardless of where you're being paid, it's still considered work. So it's a very old school way of thinking things. But as far as US immigration is concerned, if you're physically on US soil and you're working, then you better have employment authorization to do that. So just something to think about. Now, the other thing often also is that each time you come into the United States, the officers at the airport will make an assessment of whether you are in compliance with ESTA. So while they see on your record that you may be traveling back and forth a lot, they may wonder whether or not you're really working in the United States and you're trying to avoid going to see your immigration lawyer to help you get the proper visa, right? So there's something to think about. All right, Scott, do you have anything to add to the ESTA piece?
No, I just, there's a bizarro thing coming, which is all these people working remotely, and some countries are trying to get out in front of it. So Bermuda, the UAE, I think Barbados, these are places where you can get a work permit. If you can prove that you're making like 60 grand a year and you have an employer somewhere, you can get a work permit to go live in Bermuda and work. But the fact that these opportunities exist reinforces the fact that you can't come to the U.S. and do that, right? You can't come to the U.S. and just hang out and work for an employer in France without work authorization, and typically sponsored by them with their operations here. So the U.S. is behind that curve and probably will stay behind that curve for the foreseeable future.
Yeah, and I agree with Scott in the sense that one thing that is, we are in a global market and global society, and everyone's moving around a lot. Even in COVID, I have people traveling a lot. But the takeaway is that each location has their own set of rules, right? So you may be coming from a country where there are certain immigration rules that would allow you to do what you're doing, but be careful because wherever you end up, you also look at the local rules. And speaking of work authorization and getting work permits, I'm going to turn the time over to Magaly to talk about this latest thing, the H-1B.
Great, thank you, Vince. As some of you may know, the H-1B visa is a non-immigrant visa, temporary visa that is designed for those who are going to be engaging in specialty occupation type of work. To qualify for the visa in general, there has to be an employer-employee relationship, a legitimate relationship. The offered position also has to meet the specialty occupation definition, and that means that the position requires theoretical and practical application of a body of specialized knowledge, which is typically gained through a bachelor's degree in a specific field or its equivalent. And I think usually this is the piece that we're always, I'm sure Scott has done this as well with his friend, that this is where we're really looking and doing the analysis to make sure that the H-1B is an actual possibility for this particular type of beneficiary. So even though this lottery year, that things have changed a little bit in last year and then this year, we still want to make sure that we do this analysis to ensure that this will be a viable petition if selected. In addition to that, there has to be a wage that needs to be paid, usually assigned by the Department of Labor, and the beneficiary needs to have met or have qualified with a specific degree or have the equivalent of that bachelor's degree to be able to qualify for an H-1B. So this year is the second year that the H-1B registration, electronic registration, was in place. And in this year, the registrations were submitted between March 9, 2021 to March 25th, 2021. It's been relatively easy to do it. I think we have found that many times we even have a last minute registration that can be done because the system has thankfully so far worked pretty well. The selection process did finish on March 30th, 2021. And about 30,000 registrations were submitted in comparison with the previous year, which used to be 275,000 or roughly 275,000. So this does mean that—
Just to clarify, it's 300,000, right? 300,000 were filed? Yeah, got it.
Yes, oh, my apologies.
No
Yeah,
problem.
I make Magaly think of smaller numbers because her salary, right? I try not to.
300,000, you are correct.
There you go.
And so they've been selected. So starting April 1st, so now employers, petitioners can file the H-1B now with USCIS. And you'll be able to file these petitions through June 30th, at least through June 30th. As I mentioned, last year, it was the first year that we had it. Current estimates right now seem to be very light. I think for many firms around the US, it's about 25 to 35% of the cases that were registered were actually selected. Last year, there was a second lottery round 2 in the summer, but we are not sure at this moment if USCIS is going to conduct the same this year.
So just to chime in, we were talking about this before the panel went live, and something's not right? Something doesn't seem right. So the numbers are 300,000. I think most of the firms that we've talked to, we saw our number of registrations down, and we're a pretty good barometer. We got a lot of clients. So either there's two theories out there. One is that the USCIS is, selected less cases than usual because in the past 4 years they denied a ton, right? So we have a new regime in place, and they don't expect to have tons of RFEs and tons of denials, which is good. It's great for our clients if they don't have to go through this RFE process and and get cases denied. On the other hand, there's the possibility that somebody filed a whole bunch of these and we don't know who they are. So we'll keep our ear to the ground. But that 25, if you're an H-1B employer and you filed a bunch of these and you're like, why did I only get 28%? We're scratching our heads as well, and we're all working to get to the bottom of it.
Right, and I think the other thing to say is that we're seeing that these numbers are across the board. So we are not seeing, it has nothing to do with the region or the law firm you're using or even the size of your firm. We have, registrations for companies where they have one registration and they got that one, so that's 100% for them. And you have other ones with a whole lot more and they've gotten much less. So I'm sure you're seeing the same thing, Scott, right?
Yes, that's correct.
Yeah.
Okay. All right, so we have a bunch of questions. So I think the most efficient way to do this is I'll just read off the questions or summarize them, and then Vincent, Magaly, if you can field them, and if I want to chime in, that's great. So the first one, the executive order on L's and H's has expired on March 31st. So the only travel ban in effect for French nationals remains against Europe. So we are U.S. immigration people, and I think this is a European immigration issue. But if there is in fact a ban on French nationals traveling into other European countries, I would assume that still remains in effect, because this would have no effect on that. Yeah,
and if the question is about also getting into the U.S., it's right. There's no visa issuance issue, but there's a very practical, as Scott had mentioned, getting a visa at the U.S. consulate. And then also, as far as getting into the United States, you'd have to make an argument for the national interest exception. I think there's a question down below that does talk about, do I, if I already have a visa, if I don't have a visa, if I have a visa, I think the question is, if I have a visa, what do I need to do? And if you have a valid visa, in theory, you could come, but you still also have to make the national interest exception argument unless you have a U.S. citizen, spouse, or family member.
Great. Next question, right on point. Is the backlog we've been discussing relevant to those who have an adjustment status pending? And the answer is no, right? So that those people, if you're here and you've got an adjustment status application pending, it's going to be processed by USCIS in whatever the processing times are for your jurisdiction. And, I think that hasn't been affected. Vince and Magaly, that seems to be trucking along. Cases are still getting approved.
That is correct. I think the only thing that I would add is that we are seeing large delays or long delays with adjudications. I think due to COVID and everything else, we are seeing that even for a while, receipts weren't being issued for 3-4 months or so. So just something to keep in mind, that even though you file, and certainly it's in the process, and that's a good thing, it might still be a little bit of a wait to actually get that green card.
Great. All right, then the next one. Oh, go ahead.
I'm going to jump in a little bit because I'm seeing a lot of bubbles pop up, and it's the same question. I just want, regardless of your visa type, the regional travel ban applies to everyone, right? So it's not. Don't confuse the two. So if you're not subject to getting a visa, the travel, what country you're coming from, it has nothing to do with your citizenship. It's what country are you coming from, right? If you are physically in France, if you are a Turkish citizen, but you're physically in France, then you can't, in theory, directly come to the United States unless you get an exception.
That also applies, if you are in India and you are coming to the United States, don't book a flight through France and then take a couple of days and go see the sites, because you're going to be subject to a bar because you're coming in from France. So just that's popped up a couple of times.
Yeah, I would say not even a few days, right? Even if you're in Charles de Gaulle for a layover, the next flight, they may not let you onto the
plane. They may not let you in. Correct.
Correct.
Okay. There was a question about the interview waiver, and can that help you skip the line and get an H1 or H4 faster? No. So the waiver, at least the one that I was referring to, is for somebody who has a valid visa that hasn't expired. I'm sorry, that has expired in the last 4 years. But that if you don't have a valid visa, then you're not going to be eligible for that waiver.
Yeah, and there's a question here also about, is there prioritization for people who already have a visa sort of to get it renewed? Unfortunately, it hasn't. And we are unfortunately hearing that a lot of consulates last minute will cancel an appointment. So we do caution people, just because you have an appointment, or you maybe should schedule as far as soon as possible if you think you need the need, but there is no guarantee that that appointment will hold, right? Because while the COVID situation in America looks one way, you know, the COVID situation in Paris, for instance, or, you know, in London could be really different, and it's also very fluid, and they may just shut down as well. So just be mindful of that. Great.
Unrelated but relevant question. So expected timeline for the Biden bill, unknown. You know, I think if the theory that there could be a third bite at reconciliation is a real thing, and if the Biden administration decides that immigration is the third most important thing on its agenda, then it could be soon. But both those things are highly unlikely. So I think nobody knows, and probably not for a while. And then you get into whether is there a 2-year window, and you know the Republicans are going to take the Senate back in the next election. I don't know. And if that is a realistic expectation, does that mean this becomes a real priority, you know, later this year or next? These are all the different factors, and we just don't know yet.
Yeah.
Several clients married to U.S. citizens who expect to get a green card this year. Is that realistic? Sure, if they filed, you know, what's the processing time in Boston for a marriage-based adjustment case? Is it a year, something like that?
We're seeing they've caught up. So during COVID, It was a while. Most recently, I just went in for an interview yesterday for clients of mine who filed in October. So what is that? About 6 months, 6-7 months is what we're seeing. So that's definitely something to be mindful of. I also see a lot of questions about, you know, citizenship and getting a green card. The process is not harder. It hasn't changed. I mean, I know that it's a change of administration. There are, you know, new proposals, but the rules themselves haven't. And if you're in the greater Boston area, I will have to say that the officers here, whether it's in Lawrence or in Boston or even down in the Rhode Island area, have been very fair. Magaly, would you say so? I feel like they've been very, very reasonable, and things do move along quite well.
I agree. I think the interview process has remained the same. The officers are still very reasonable. They're taking all precautions necessary for COVID due to COVID concerns, but it's just, you know, unfortunately just waiting for that interview to be scheduled.
There's a question about E2 non-immigrant visa renewal. You know, there is an option to renew an E2 or extend it in the United States, but usually it's not that useful because once you leave, you got to go back into the consulate anyway. I don't think there's any carve out to expedite E2 visa extensions at any U.S. embassy or consulate that I'm aware of. And then the issue of, I personally don't know what the current visa validity on a French E2 is, but you know, from the question, it looks like it's less than 5 years, and I don't know if there's any initiative to try to get that back to 5 years. That's a diplomatic thing. It's usually based on reciprocity. And one thing that the Trump administration did is they looked at all this stuff and said, "Hey, China, if you're only giving us, you know, a year, then we're only giving you a year." And so that I think that's why a lot of these visa validity periods have shrunk in the last 4 years, because they're just trying to line them up with what other countries were doing to us.
Yeah, I say, you know, if you want to do any advocating, then I'd say, you know, help the relationship between whether it's, you know, the U.S. and France or the U.S. and China, U.S. and the U.K. I mean, that's actually where the visa validity period, you know, and again, as Scott alluded to, it's a reciprocity. It's a mutual agreement, I guess.
Okay. There was a question, and this actually came in a few days ago, about, you know, ability to change employers once an adjustment is pending, and the answer is as long as you've been, you know, had that adjustment application pending for more than 6 months, then there's a process through which you can switch employers and continue to pursue that green card application. If it's before then, it gets much more complicated, but it's always possible. Especially, you know, the bottom line is you can't be like working in finance and suddenly you're going to go and become an architect under the same petition, right? It has to be the same sort of role and same requirements, but it's always possible at any point in the process to switch employers. It just depends on how much work it is. Yeah. I saw, and I'm jumping around here a little bit.
I see some questions.
Yep.
Some questions have to do with, you know, visa issuance and visa renewal. If you're here in the United States, if I'm reading the question correctly, you don't, in theory, need to apply for a new visa while you're here in the United States. So your time here in the United States is really governed by the expiration date on your I-94. And then you can get that extended stateside. It's only when you have to travel internationally that the visa itself becomes an issue. So just sort of a heads up on that.
Getting an NIE with ESTA would be just as difficult as getting an NIE with a work visa application, right? It's the same criteria, so it's going to be just as hard. It's not any easier. We get questions all the time about whether somebody should apply for citizenship. First of all, if you're renewing your green card, that's just it's a process. It's like renewing your driver's license. You don't have to show that you qualify again. You just have to show that your document's expiring. They want an updated picture. So the filing of that application is quite straightforward. Decisions on naturalization get into tax. If you are from a country where we don't have a tax treaty, you definitely want to talk to an accountant. And Ken Vakovic's on the line. Just posed a question. He, I'm sure, be delighted to provide some tax advice from his law firm. But that's a driver on citizenship. I would say that we probably were more likely to advise people to apply in the last 4 years because of fear that they may lose their green card for some reason than we are now. And so, to Magaly's presentation, it's just like the voter laws in Georgia, right? So there was a real push to try to make it really hard for people to get citizenship because new citizens are Democrats, right? That's it. Just statistically, most new citizens are Democrats. So when the Republicans are in control, they try to make it harder, and when the Democrats are in control, they try to make it easier. It's politics. But right now, it should be easier and a good time to apply for citizenship. So there was a question we didn't talk about E's, 2's. I mean, nothing's changed. Let's put it that way. There's no change in our treaties with any of the countries that are qualified to do E visas. It's just COVID, so it's all the same requirements. Nothing has changed. H-1B academics still be able to get an NIE. Sure, if they're eligible, if they meet the NIE requirements, then being on an H versus a J as an academic or professor, you're going to have to go through the same process.
Right. There's also a question about spouse. Can you leverage your spouse's reason for being in the United States? And Magaly and I have done this for a lot of employees that we represent, where their spouse has a good reason to get an NIE. We've used that argument, and again, it's discretionary. It is up to the officer. I mean, I think it's a good one. And I would definitely try for it. And honestly, with a lot of the consulates, it is a matter of just emailing them some of the supporting documentation in your argument. And so long as you're outside the country, you can do that, right, Magaly?
Right. I would say I think the tough part is there's no strict, there are some guidelines, but they're not, specific. If you meet all of these guidelines, then you'll definitely get issued that NIE, and every post is different. And so we are seeing that, if the French embassy may approve of one, but then the Spanish will not, it's just all over the place. Unfortunately, as Vince says, if you're already in that country, then you can go ahead and try to ask for that NIE. Many of them will just allow you to just send your documents via email and present that argument. I think the question is much harder if you are in the United States and now you're trying to go back to Europe for any reason, business reason, personal reasons, then you do need to assess, does it make sense to travel at this point? Is your NIE argument really strong or not? And sometimes even when they are strong, they might not be approved. I was on a call with some of other colleagues with the AILA Department of State liaison committee members, and many of them are reporting some of them who have really strong arguments to come back. An applicant who works for a company that produces very important vaccines is being denied. So how is that, being consistent? Whereas in some cases, other applicants are just executives of another company, and it's, maybe promoting jobs or helping in the economic recovery, and that one got approved past after March 2nd. So sometimes there's some inconsistencies, and that's the issue and the struggle that I see many of our clients have when they're trying to travel abroad. But if you're already abroad, and it's not going to harm to try to go ahead and ask for the NIE.
Yeah, so bottom line, if you're here and there's any risk that you're not going to be able to get back in, don't go. We're running a little short on time. Just to kind of summarize some of the questions, these NIE rules apply generally across the board. So there's no, one visa category is better than the other, or I'm only a visitor. It doesn't make any difference. In terms of timing, it's all about vaccination rates, period. Right. So the faster that folks get vaccinated in a country of departure, and in the country where they're going, the faster this gets squared away. So I would anticipate that the U.S. seems to be cooking along, and so we'll get to a place where that the staff in India, won't be able to go into Chennai and process all these applications because the vaccine rate is relatively low and the COVID infection rate is high. And that's what you want to keep an eye on. And the same thing in France at this point in time. On the other hand, the UK seems to be, chugging along, and they're talking about opening up a travel corridor between the US and the UK. That could happen. And there would obviously be a benefit to folks who are British nationals to be able to get in easier because that's the driver. The vaccination rate is the driver, and the COVID infection rate is the driver. And all this other immigration stuff is not relevant. At the end of the day, that's what's going to move this along. I know that we want to, I think we have a couple more minutes. So there's a question about green card backlogs. Now, in terms of processing, it's all about these visa numbers. So if you're from India or China, you got to wait until your prior date is current. So that's where we were talking about a big backlog. There, at this point in time, if you're a French or UK citizen, you're typically not subject to those backlogs, or not significant ones. So you should be okay. E2 visa, we talked about. Reopening, the executive order, we talked about that. I'm just seeing if we missed anything. We talked about that. Now, someone had quite, L1 visa valid until 2023. Well, this is going to get solved before then. I'm going out on a limb. So if but don't travel, right? If you're here in the US, you're on an L1 visa, it expires in 2023, unless you have to go back, or you are working on, you work for Moderna and you're working on the vaccine. You want to talk to one of us or someone in the field to say, what are my chances of getting a national interest exception? That's the question. And you got to do that before you leave. So that's going to be the driver.
Right. And I think, to go along that point is the expiration date, again, to emphasize, while you're here in the United States, you don't need a visa stamp in your passport that is valid to stay here. It is only when you travel internationally. So when you're stateside, whether you're on an E visa, an L visa, or student visa, all that, you could in theory file an application to change to another status or to extend your time here. I think one of the questions here has to do with an F1 student status, and where they look at the expiration date, it says DS, and that says duration of stay. What does that mean, right? When does my time expire? And in most of those cases, your allowed time to stay in the United States expires when your academic program is over. Or if you have a work card, an employment authorization card, it usually expires, corresponding to that. There's a little grace period, but that's what determines it. And if you really don't know, I'd say definitely, talk to your school, and they should be able to help, or, call one of the attorneys, and, we can look at your documentation. But there is always somewhat of an expiration. You can never stay for a long time. And I know that your visa may be for multiple years. The stamp in your passport may be multiple years, but that doesn't mean you get to stay that long. What ultimately governs is that I-94. Back in the old days when I first started practicing, it was a little white index card that you'd get on the airplane, but now it's all online. So go to I-94 CBP, Customs Border Protection, and you should be able to type in your information to see what's on their record.
Okay, very quickly, because we're out of time, I'm going to just summarize 4 things, and I'm going to turn it over to Annabelle Reeve from the British American Business Council to close this out. So, and this, I don't know the answer to this question. So spouses in the States does medical research on COVID. I'm abroad. Can I get an NIE? Can the family member apply for an NIE when the spouse is already here? I don't know.
Yeah, we've actually, Scott, so we've tried that, and we've been successful. But again, as Magaly pointed out, it is discretionary. And if you're already abroad, then go for it. Apply. There's no harm.
There's no harm. No downside.
Your visa or anything.
Okay, it's definitely possible to adjust from an L1 for one company to a green card for another company, but you're probably going to want to go. Actually, no. Let's back up. No, I take that back. So if you're on an L1 for one company, unless the other company is related to the company you work for, it's not possible to switch employers easily. So you'd want to talk to, again, one of us about that before you accepted the offer from the other company, because that gets very tricky. It may not be possible. There's no way to speed up a green card application, not really. So that's probably not going to be feasible. And then if you're on an E2 and you're I-94, your status is expiring, and you don't want to go abroad to get the new E2 because you may get stuck. There is a process by which you can file, your employer can file to extend your E2 status here in the United States. and you file the petition with the US CIS, and it'll allow you to stay here. But once you leave, you're going to have to go through a pretty convoluted process to get your new E2 visa. So it's just a lot extra work. But if your status is expiring, you should definitely be extending it here. Okay, Annabelle, how are you?
I'm good. Thank you very much. And yes, thank you all for a really fascinating presentation. And to say by the number of questions, I think everyone's been really interested. I'm hoping for the UK US air bridge to open. So that's my fingers crossed so I can go and see my family. But no, thank you very much to Vincent, Scott and Magaly, and also to the French American Chamber of Commerce for organizing with us. And I'm part of the British American Business Council. I'm actually the president. And so work closely with Scott on that. So thank you all very much for joining. And I'm sure we'll have another follow-up, as I'm sure some of these rules will continue to evolve. So thank you all for your time today.
Thank you, everybody. And any questions we missed, we'll try to reach out to the people directly and we'll field them. But we appreciate your input, tons of questions. We hope this is helpful and we hope you have a great rest of the day. Thank you.
All right. Bye-bye, everyone. Thank you.
Bye-bye.
Bye-bye.